Hi everyone, welcome back, and I should start by saying thanks very much for all the positive feedback on the first few videos. I'm really glad people are finding them useful. I've called this episode How to Get to the Tilted Balance. I looked in episode 1 at the recent Gladman judgment, which considers the question of how the tilted balance in paragraph 11d2 of the NPPF should be applied where it is engaged. So in this episode I want to consider the question that comes prior to the question in Gladman and look at the circumstances in which the tilted balance will be engaged. So the first step in reaching the tilted balance is that either there must be no relevant development plan policies, or the policies which are most important for determining the application must be out of date. Looking first at the circumstances in which there will be no relevant development plan policies, as Sir Duncan Ouseley explained last summer in the Paul Newman decision, if one or more relevant development plan policies exists, then this trigger for the application of the tilted balance can't be applied. The development plan policy in question doesn't have to be up to date for this trigger, it doesn't have to be important for determining the application, it simply has to be relevant. And Sir Duncan Ouseley in Paul Newman makes clear how wide the category of relevant development plan policies is. It includes general development control policies such as the provision of adequate access to the highway or adequate sewerage. So in practice, this trigger for the application of the tilted balance will be unavailable in the vast majority of cases because it will be simple to identify at least one relevant development plan policy. I should note though that Paul Newman has been appealed and is currently down as due to be heard by the Court of Appeal in July. So that's relevant policies. Looking at most important policies and the circumstances in which those will be out of date, the first point to note of course is footnote 7. So where the application involves the provision of housing, the most important policies will be deemed to be out of date if the local planning authority doesn't have a 5-year housing land supply, or applying the housing delivery test, it's delivered substantially below the housing requirement over the previous 3 years. The next question is where footnote 7 does not determine the answer, then in what circumstances will the most important policies be out of date? And there are a number of references to consider here. First, in last year's Wavendon judgment, Mr Justice Dove confirmed that the approach previously taken to the meaning of out of date by the High Court in Bloor Homes in relation to the original 2012 NPPF is of equal application to the revised NPPF. So a development plan policy will be out of date where it's been overtaken by things that have happened since it was adopted, either on the ground or in some change in national policy or for some other reason. Next, the NPPF itself, of course, at paragraph 213 explains that existing development plan policies shouldn't be considered out of date simply because they predate the publication of the NPPF, but should be given due weight according to their degree of consistency with the NPPF. Then a development plan policy is also not out of date simply because it's in a time-expired development plan. That's been confirmed both in Wavendon and in Paul Newman. Another point that's been discussed by the courts recently is the argument that a development plan policy that doesn't include an internal cost-benefit analysis will automatically be out of date because such an absolute approach is inconsistent with the more nuanced approach taken by the NPPF. So, for example, you might have a development plan policy on heritage assets that simply states that designated heritage assets must be preserved, and which, unlike the NPPF, does not go on to say unless countervailing public benefits outweigh the harm. The decision of Mr Justice Garnham in Eastleigh confirms that a development plan policy will not be out of date simply because it does not include an internal cost-benefit analysis. What's instead required is a comparison of the development plan policy and the relevant parts of the NPPF. So that's how you determine whether a particular development plan policy is out of date. The next question is how many of the most important policies need to be out of date in order for the tilted balance to be engaged. We're of course still assuming here that footnote 7 doesn't apply. This is the point that's addressed by Wavendon, or one of them. The decision maker should not assume that as soon as a single most important policy is out of date, the tilted balance will be engaged. Mr Justice Dove in Wavendon was clear that not all of the most important policies need to be up to date in order to avoid the tilted balance. The correct approach is as follows. First, the decision maker needs to identify which of the development plan policies are the most important policies. As Sir Duncan Ouseley put it in Paul Newman, the decision maker needs to identify the basket of policies from the development plan that constitute those most important for determining the application, although we'll come back to baskets in a moment. The decision maker then needs to consider whether each of the policies is out of date, and then take a holistic approach and reach a judgment as to whether, taken as a whole, the most important policies are to be regarded as up to date or out of date. So is the basket, when viewed overall, up to date or out of date? It's possible, therefore, that where only one of the most important policies is out of date, the most important policies as a whole will be out of date, but that's not automatically the case. And the fact that one or more policies in the basket is out of date is relevant to whether the basket as a whole is out of date, but it's not necessarily determinative of that question. Note that there's no requirement that the up-to-date basket of most important policies must itself amount to a body of policies that suffices to enable the acceptability of the application in principle to be determined. In this regard, there's been a lot of talk about baskets since the decisions in Wavendon and Paul Newman, but it's important not to lose sight of the fact that you don't necessarily need a basket of up-to-date policies. It might be the case that there is only one up-to-date development plan policy, but that it is important enough alone to justify the conclusion that the most important policies are up to date. So returning to paragraph 11D, if either there are no relevant development plan policies or the most important policies are out of date, the tilted balance in paragraph 11D2 will apply unless the application of a footnote 6 policy provides a clear reason for refusing planning permission. This is footnote 6, and it's the subject of a very helpful judgment of Mr Justice Holgate in Monkhill, although an appeal was due to be heard by the Court of Appeal, but the hearing was vacated on Friday, so it's currently down as awaiting a hearing. The relevant points to take from Monkhill are as follows. First, it's not enough that a footnote 6 policy is engaged. The test is whether the application of the footnote 6 policy provides a clear reason for refusing planning permission. Where the application of the footnote 6 policy does provide a clear reason for refusing planning permission under paragraph 11D1, the decision maker must not go on to rely upon the tilted balance in paragraph 11D2 to grant planning permission. So the decision maker should consider paragraph 11D1 first, before going on to consider 11D2 only if footnote 6 policies do not provide a clear reason for refusing planning permission. Note, however, that in applying paragraph 11D1, the decision maker must take into account only those factors that fall within the ambit of the footnote 6 policy, so other NPPF policies and development plan policies are not to be taken into account. However, the application of some footnote 6 policies, such as Greenbelt, require all relevant planning considerations to be weighed in the balance. So in some cases, the outcome of the footnote 6 policy assessment determines whether planning permission should be granted or refused. Where that's the case, there's no need to go on and apply the tilted balance because there's no justification for doing so. Mr Justice Holgate also considered that the approach would be the same where the application of a legal code for the protection of a particular area or asset determines the outcome of a planning application, and he gave the habitats regulations as an example. In other cases, though, the application of the footnote 6 policy does not require all relevant planning considerations to be taken into account. Mr Justice Holgate gives paragraph 196 of the NPPF as an example. That paragraph requires the harm to the heritage asset only to be weighed against the public benefits of the proposed development. In such cases, where the application of the footnote 6 policy does provide a clear reason for refusing planning permission, then all other relevant considerations must still be considered, but the tilted balance must not be applied because the presumption in favour of granting planning permission has been disapplied by the footnote 6 policy. The final point to note is that where more than one footnote 6 policy is engaged, then planning permission should be refused where the individual or cumulative application of those policies produces a clear reason for refusal. So that's a quick explanation of how to get to the tilted balance. I hope it's useful, and take care.